Hello everyone and welcome to the BRR Media Legal Brief, where we bring you the latest legal issues affecting corporate Australia. I'm Kate Ritchie, and this week we're navigating the various obligations and risks that businesses face when it comes to employment law. And joining me to discuss is Jonathon Corlett, who's a senior lawyer at Truman, Hoyle. Jonathon, thanks for joining us.
Thank you, Kate.
Well, Jonathon, firstly I'd like to get your opinion on what you see as the key issues facing businesses in employment law in 2013.
I think that the key issue this year is going to be the federal election. Who wins the federal election this year will have an impact on what the workplace laws will look like. In terms of the coalition, we're not precisely certain what they will do, but they have been distancing themselves from work choices since 2007 and their loss there. The federal government, the Labor government, have been a little bit more open about what they're prepared to do, and we've actually seen a couple of recent announcements. We may see more. One of those announcements is to extend flexible work arrangements beyond the current limits that are in place to apply to people who have got carers responsibilities, to people who are mature age and looking perhaps to wind down their career at the end of their career, and also for employees who are suffering from family domestic violence situations. Another area where the government just last week made an announcement was in relation to right of entry by union officials, and they're actually looking at expanding the union's ability to meet with employees in their lunchroom, which has been a contentious issue for the last 5 years. So I think, at least for the next 6 months, the dominant employment issue is going to be the federal election.
Well, one of the dominant issues last year was, of course, the review of the Labor legislation, the Fair Work Act, and a number of changes have been brought in. What were the main changes, and do you think that the changes went far enough?
Well, in terms of whether they went far enough, I suppose it's not a matter for me to comment on that, but in overall terms, there weren't many recommendations that were made by the review panel. There were 53 recommendations, many of which were quite technical in nature. Generally speaking, they found that the Fair Work Act was operating well in the circumstances. Some of the changes that have been implemented to date have been non-contentious matters, and they have included change to the name of Fair Work Australia to the Fair Work Commission. They have also provided for a common time limit for lodging unfair dismissal and general protections dismissal claims to 21 days instead of 14 days and 60 days respectively. They also prohibit a union official from acting as a bargaining agent or representative in terms of a proposed enterprise agreement if that union official's union doesn't actually have the ability to represent the employees. So there could very well be other changes that arise from the review, and one of those areas is actually the flexible work arrangements, which I just mentioned.
Well, I'd like to look at some other proposed changes, and they are the federal anti-discrimination law changes which are currently on the cards. Obviously they're dependent on who wins the election, but assuming that the changes do come in, what will it mean for employers?
Instead of having to deal with 5 bits of legislation, which an employer currently has to, there was one consolidated piece of legislation, which generally speaking I think is a good thing. Creates more efficiency. You're not wondering whether there's a common term in one legislation compared to another. There are some of the changes that have been proposed, though, don't impact an employer as positively, I don't think. One of those is a reversal of the onus of proof. Instead of the employee having to prove or make out their claim, an employer will have to show that any unfavourable treatment that the employee alleges was actually due to, or not due to, prohibited attributes that an employer is not allowed to discriminate against, such as gender, age and ethnic background. So that's one problem, I think, for an employer. Another problem that I see is that there is, in terms of legal costs, unlike presently where costs follow the event, the winner has their costs paid for by the other side. The government is proposing a no-cost arrangement where, except in exceptional circumstances, the employees actually, or the parties bear their own legal costs. And what I think you might see here is employees trying on claims which they might not previously have done. So you might see an expansion in the number of claims that are lodged by employees against their employers. But as you said, it might very well depend on who gets into power after the election, so it's a matter of wait and see what happens.
It certainly is. I guess one of the hot topics, continuing hot topics for businesses is social media. I want to focus, I guess, on when employees use social media. What are the risks still facing employers in this area, and were there any major lessons learnt from last year?
Well, one of the issues with social media is that even if an employer doesn't use or utilise social media in their business, their employees inevitably do. Everybody's on Twitter or on Facebook or on LinkedIn. So what I think that some of the issues for an employee or an employer are is where employees actually use social media to harass, bully or intimidate other employees. Now there's been cases that have dealt with those type of issues recently. There's also the potential reputational damage that an employer might suffer if, for instance, an employee is outed as a Twitter troll, which has also happened quite recently. And another key area is what happens to an employee's connections to an employer's clients and customers when they leave, if they've connected through LinkedIn and Facebook. Now, there's the potential that those connections could be used in the employee's new business for the new employer to the detriment of the old employer.
Well, I guess just finally, there's a number of obligations and risks that you've mentioned there. What would be your top tips for businesses managing the various employment law issues? Well,
as with most employment issues, I think be proactive. It's better to deal with a risk rather than face a problem that leads you into court. So a couple of tips that I have is in terms of employment contracts, particularly for the subverting of the connections with the clients, have an express term in your contract which deals with what happens to those connections once you leave, which might involve the employee disconnecting with those clients and customers. The other area is the implementation or establishment of policies and procedures which clearly govern and regulate what an employee is expected, or how an employee is expected to behave through those social media outlets. Look, it's with the blurring between an employee's work life and their personal life in the 21st century, I think that it's becoming increasingly harder for an employer to say, well, I'm not responsible, because that's done on the employee's own time.
Yeah, well, certainly some things to consider there, and it'll be an interesting year, I think, to watch to see what happens with the election as well. Jonathan, thanks for joining us in the studio.
Thank you, Kate.
And viewers, thank you also for joining us. We hope that you can join us next week for our legal brief.